right. Court is calling 2025 CR 000701 State versus Felipe Reyes. Could I have parties announce? Well, my understanding is you all are only proceeding on one. Is that correct? Is this the cause number you all are proceeding on for trial?
Unless they want to consolidate, we'll go.
All right. Do you all want to consolidate the cases and go to trial on both of them? All right. Let's put it on the record. Mr. Reyes, if you come forward, please. All right. Then this is 2025 CR 000701 and 2025 CR 000700 State versus Felipe Reyes. Can I have parties announce? And also for the state? All right. The first things is it was the court's understanding that you all were only proceeding on one case. Defense, my understanding, you requested that the cases be consolidated. All right. And are these cases on different dates?
No, they're out of the same.
All right. So, Mr. Reyes, your attorney is asking that these cases be consolidated, which means that they be tried together. Do you understand? Can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand, state your name for the record. All right. Do you have any objections to these cases being tried together? All right. So then both cases will be tried together. And counsel, if you could, I will need an additional cause number, I should say, written on the election of punishment, the written sworn motion for community, request for community supervision. Yes, you submitted them separately, but when we do the jury trial, it's going to be all on one charge, and I don't want any record to be unclear if this is appealed. Yes. So if you'll just make sure you do that for the election for punishment and also for the written sworn motion for community supervision. Yeah. And also for the trial court certification. And if you want to, you can it's already been file stamped. So you'll probably have to do just another one since it's already file stamped for the record.
Okay.
All right. And Yaya, if you could do another trial court certification, and it's going to be both cause numbers. Yes. And Yaya, I don't know, do you need to do something specifically as far as judgments are concerned, if judgments need to be made since they're combining the two cases?
I'll have to ask the court.
All right, because I know Odyssey has changed things.
Yes.
Right. So there's something else you wanted to go up?
Yes.
Yes.
Like there is an issue concerning several of our Constitution. We believe that first is concerning the fair trial under the 6th and 14th Amendment, as well as his due process rights under the 14th Amendment is under the due process rights is entitled to fair trial. And so we feel like since the state does extend law enforcement officers, they have been in possession of this evidence for months. We just got access to, I believe it's a total of 6 videos as of today. 2 more were uploaded while we were reviewing evidence with Felipe today. We were only able to get through 2 of them with our client. They are extensive, and since we did review them, we were able to actually identify some material against Victoria evidence. And so that is why we do it's important to be able to have that time to review them.
State?
I agree.
No, I'm not asking whether you agree with their argument or not. I want to know whether or not you just uploaded videos or did they have prior access to them. That's what I want to know.
No, these recordings were uploaded within the past 4 days.
All right. Next. Is that all she's alleged in the motion for continuance? All right. Motion for continuance is denied.
And that being said, I'd like to take up our motion for witness list that was filed on both cause numbers on May 16, 2025. We just got the witness list on the cause numbers from the state on May 23rd, 2025, so it's not timely filing, and notice of the state's witnesses. We did timely file our test estimates, got, retained on this case. So at this point, I'm asking that the court exclude any of the witnesses that are on the state's witness.
Under 39.14, time of filing is not later than 30 days prior to trial. State's defense's request was made within the past 20 days. So that would seem to not comport with 39.14's requirements for the motions from witnesses. Moreover, the witness list specifically applies to requests for expert witnesses rather than state's witnesses in general.
All right, that will be denied.
That,
Yes.
the Supreme Court did rule in U.S. versus Akers that can you just speak? I'm sorry, here. Can you put this out, please? Apologies, Judge. So
No problem.
I would first actually like to see that Article 39.14 does require discovery 30 days prior to the date of trial, and that evidence included within that evidence is the state's witness list. And additionally, in U.S. versus Akers, which is what I was talking about previously, the Supreme Court did assert that it is essentially not limited to the defense's request for such evidence. It is anything that may be, the state does have a constitutional duty to provide anything that is sufficient. Right, so it's not strictly
And that we did file that motion for witness assessment. So it was 50 possibility for us filing it 30 days out, but it wasn't in a popular state. We've had this case for several months now. So that's another consideration I think the court can consider when deciding whether we're going to strike the witness except for the notice.
Any response, State?
39.14 is triggered by a request served upon the state. There was no request for 39.14 material served upon the state prior to this defense firm's becoming involved in this case. So they are correct that this information was not furnished prior to their filing of that notice. But under 39.14's own provisions, it only becomes operative until defense serves a request on the state. It wasn't done until they became involved.
Judge, and just further under Martinez v. State, I think that the crux of this provision is to delay any unfair surprise to the defense, and they've had access to the discovery of the prosecution guide and the videos, and so that gives them notice of any witness that we would intend to call in trial.
All right, that's denied.
Judge, so the next motion that I wanted to address with the court was looking to require to state your the appointment in a report. So are we going to, I guess, run that this trial?
Well, my understanding, and this was done off the record in the presence of defense counsel. I'm sorry, in the presence of defense counsel, the state informed the defense that that was an anonymous tip, and that anonymous tip was done through Crime Stoppers. Is that correct?
Yes, that is what the detective responsible for this case told me.
So is there an informant in this case? Because there's a difference between a confidential informant and an anonymous tip.
As far as I'm aware, Judge, no, there is not a confidential informant involved in this case.
So they're saying there is no confidential informant. That's what the cross-examination is for.
Yes, but if it comes out that it did involve a confidential informant, then there's no going backwards, because we may be entitled to know who that confidential informant is that we can use to prepare for trial if they were able to inform and know that information that is exculpatory or mitigating for my client. And at that point, it's going to be too late during the actual in-trial testing of that.
Well, it appears to the court as what you're seeking is to have the benefit of cross-examining every witness before a jury is seated to hear the cross-examination. The state has informed you that there is no confidential informant. So There is no hearing to be had where outside the presence of a jury, you question every witness and say, was there a confidential informant involved in this case? The state has told you there is no confidential informant. There's anonymous tip from Crime Stoppers.
Is that, I mean, we were also told by the state, there was also representations that there were not recordings for one of the officers in this case, that the body worn camera or no dash camera existing, like actually required them to inquire as to that. Well, then dash camera and body worn camera for the officer that state previously they didn't have, she ended up popping up. So we have to be very careful with this case because of all the different parties involved and just taking that information at face value. I really do think it is only one officer, but you could also take the motion to suppress with that one officer as well. And determine the admissibility of all of this, because the appeals court have said that the trial court is right to determine a state refusal to identify the informant, where the officers either claim that they no longer have the informant's details or agree that the informant had this place.
But they're saying they don't have an informant. So the fact what you're presenting to the court stating that there are specific reasons for the court to grant the release of an informant's identification, they're saying an informant does not exist.
That's what they're saying. That I did here to actually.
All right. So is there anything else? All right. Are the jurors outside? All right. Each side will have 30 minutes. This is the court's question. Yaya, do we have the indictment in each of these cases? Are they here? Let me see. I don't know why I have that. So that's that. Let me see if I can find it. I have this. All right. So are you all proceeding on both counts in each indictment?
Yes.
Yes.
Okay. So let me make sure we're off the record. Let me make sure I have this correct. So in 2025, the case ended in 701. Count 1 is possession. Penalty group 1, 400 grams or more. Okay, I'm sorry. So count 1, possession with intent to deliver. Penalty group 1, over 400 grams.
Correct.
And then count 2.
Good afternoon, Your Honor.
Good afternoon. And if anyone left their phone at Smashing Crab, Deputy Laura has it. It is in the 187 District Court.
Wait, you happen to know where the state's file is?
Renee, Roberto, you, and
No.
Leslie, y'all may need to defend Deputy Laura. All right, court is calling 2025 CR 00065. State versus Eduardo Jose Medina. Can I have parties announced?
Andrew Harris, from state.
Your Honor, Mark Braswell for the defense.
And are you Mr. Medina?
Yes, ma'am. Yes, Your Honor.
All right, is that Aaliyah? Who is that?
Yes, that is Lee.
Yeah, it's all right.
Yes, ma'am. Very much. Very much.
Counsel, have you received all discovery?
Yes, Your Honor, I have.
Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Medina, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Believe so.
Let me see here. All right, Mr. Medina, did you review the court admonishments with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with a collision involving serious bodily injury as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Medina, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $500 fine. State recommends deferred adjudication. There's to be restitution of $6,000 to Madison Candles or Matt Camp. Oh, is this Canales? Okay. $6,000 restitution to Madison Canales or Matt Canales. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 7 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with the complainants, and the driver's safety and aggressive driving course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
To be contained in Exhibit 1 and attachments.
No
Judge.
objection, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Oh, state, you may be excused.
Thank-
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We're ready, Judge.
All right, anything you wish to say on behalf of your client?
Judge, at the time of this offense, my client was working, and this was a short lunch break. He had called in an order of food at a Chick-fil-A,
Mhm.
and went to go pick it up. And after he pulled through the line, he encountered the pedestrian. I believe it was a high school kid. It was on a lunch break, and he did stop. He did get out of his car to check on him, and then I think at that point he pulled out to a Wendy's parking lot and then fled the scene. We reviewed the evidence. We understand. I've watched the videos. I mean, the fire truck came, ambulance came. She was hurt. She was taken away on a gurney. We've agreed to make full restitution, which we believe the amount is $6,000. He's going to do that. But my client is a U.S. citizen. He has some criminal history, but I mean that this was not a act of malice. I think it truly was an accident. I think he probably got scared, maybe fled the scene. Stupid.
So when is he paying this? When are you paying this $6,000?
As soon as possible. Or,
What does that
maybe
mean?
Under a year.
But he
Are you employed?
Yes, ma'am.
What do you do?
I'm a sous chef at Pinstead.
All right, how much are you able to pay per month towards this $6,000?
Say 600, 700.
All right, here's the thing. Don't tell me what I want to hear. Tell me what you can do. Because if you tell me you're able to pay $600 per month, then I'm going to put you down as paying $600 per month. And if you don't pay $600 per month, there may be a motion to revoke file. So how much are you able to pay a month?
$500.
Are you sure?
Definitely.
100%.
100%.
Okay. Do you have any children?
No, Your Honor.
All right. Probation, there's a $500 fine that will be probated. There's a restitution of $6,000 to be payable to Madison
Canals.
Canales or Matt. Is the Matt the father?
Yes, Your Honor.
All right. It's to be payable to Madison Canales or Matt Canales in the amount of $500 per month. And that's beginning June 1st. So the month of June is when you need to start paying your $500 a month. If it's better for you to pay it the middle of the month, the end of the month, you need to let probation know, and that's when it's going to be due.
Yes, I understand you.
And probation, if you make sure that the restitution is paid first, 7 years deferred adjudication, proof of employment within 30 days, no employment as a home health care provider or with minors, regular reporting by Zoom or in person, regular random UAs, 200 hours of community service restitution. Those 100 of those hours will be deemed satisfied upon completion of the driver's safety course. The remaining 100 hours will be deemed satisfied if you decide to obtain some higher level education or some type of trade school certificate. There should be field visits 1 time per month for 3 months. And no contact with the Canalises. Is there anything else he needs probation? Is there anything else you need in order to be successful on this probation?
No, Your Honor.
All right. Did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you. In order to be successful in this court on probation, communication is key. If there's an issue, let probation know. If something happens and you're not able to make that payment, you need to let them know, and you need to have a good reason why. You understand?
Yes, Your Honor.
All right, good luck to you. Just remain in the courtroom. Probation will go over conditions with you.
Thank you, Your Honor.
Thank you,
Rest of your day.
All right, thank you. You too. All right, Deputy Laura. Gary Churick has his phone.
Okay, we sent it to court. There's that open.
Okay.
I thought it's Mr. President.
Deputy Laura, so should we leave?
No,
Not yet. Okay.
it's the law for basically people.
No. We.
Not the jury.
Court is calling 2023 CR 10151 State versus Amber Nicole Lopez. Can I have parties announced?
Megan Galloway for the state.
Matthew Brown for the defense.
And are you Miss Lopez?
Yes.
All right. Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Amber Nicole Lopez who was placed on community supervision in 2023 CR 10151 for the offense of possession of controlled substance, penalty group 1, 4 grams to 200 grams on January 8th, 2024 for a term of 6 years? Is that you?
Yes.
All right, state.
The state is proceeding on the first amended motion. And
Just 1 second. Let me see if I can find the first amended motion. Do you all have the first amended motion?
I do have a copy of
Thank you. Did you review the first amended motion with your attorney? Did you understand it?
Yes.
All right. Oh, here you are, State. I just needed to make sure she reviewed it. Thank you. All right, State, you may proceed.
violation of condition number 4. On or in Bear County, Texas, the defendant Amber Nicole Lopez did then and there fail to report to the supervision officer as directed for the months of April, May, June, July, August, September, October, November, and December 2024 in violation of condition number 4.
How do you plead to that? True or not true?
Truth.
And then violation of condition number 4 in Bear County, Texas, the defendant Amber Nicole Lopez did then and there fail to report to the supervision officer as directed for the months of January, February, March, and April 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True. We waive and abandon the remainder, Your Honor.
Any objection?
No objection.
Did you understand by pleading true to violations 4 and 4, the court could find it true, grant the motion, sentence you to 6 years in the prison and up to $2,000 fine?
Yes,
Knowing that, do you still wish to plead true to 4 and 4?
yes,
Court will find 4 and 4 true. Is there a proposed agreement?
There is, Your Honor, the state is asking that you revoke the defendant's community supervision and sentence her to 4 years in the prison.
Is that the agreement?
It is, Judge. There was some other,
So she does have misdemeanor cases pending. She's to plea on one of those cases, and then the state is going to take into consideration 2025 DC 0066. Sorry.
And let me ask you all this. So the case that she's to enter a plea and she hasn't done that yet?
Correct.
All right. So once I sentence her here, that's, the other court will do what it will do. So probably it's better practice for the 225 to be taken in consideration with that case. And you can notate for the record what she is to plea to and what you all would be taking in consideration once she enters a plea into that case. All right. And so what is she to plea to as a part of this agreement?
Well, I'm trying to get to.
Oh, no problem.
If as part of the agreement, she's to plead to 2025 CC 006886. And once she enters a plea on that case, the state will take into consideration clause number 2025 CC 006609 and 2025 CC 006889.
Right. Did you understand that to be the agreement that your attorneys have reached?
yes,
Are you asking the court to follow that agreement?
yes, yes,
Are you waiving your right to appeal?
yes,
All right. Probation, did she, and state you may be excused, probation, did she pay the restitution to Elmendorf for drug testing?
Judge, I don't see restitution was listed on the court summary.
All right, thank you. All right, the court will follow your agreement. The court will sentence you to 4 years in the prison, grant the motion, give you credit for any time served. I request the therapeutic community. There's a $2,000 fine, time, and money will run concurrently. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement. Oh, I'm sorry. Just one moment. There's to be no contact with Ramon, Ramon, Abraham Garcia, and no unsupervised contact with minors. And those were previous conditions that the court had set for you. Did you review the document? Again, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
yes,
All right, so here, off the record, here's the thing. When you are released, you need to find a place to get help so you can maintain your sobriety and so you can have some sort of place in your children's life. When you're released, if you can't find a place that can help you with your sobriety, if I'm still here, you can come back here and I will find a place for you, okay? All right, good luck to you.
thank you.
Thank you,
Thank you.
counsel.